so I just put this up here, and then here you go, okay? And this is Chris Spiewak. He's the head of AV.
I've seen you here
Oh, yeah,
plenty of times.
Yeah.
So we are live streaming it to YouTube.
Oh, you are?
So if you would stay here and use the mic, that would be appreciated.
Okay.
And we do have mics that will run out to audience members for Q&A.
For questions. You're good with questions,
Yeah,
right?
of course.
Yep. So if you, I mean, their intro will be pretty quick. We'll start right about 5, and then you talk, I don't know,
I'll
half
keep
hour.
eye on it.
Yeah, and then we have mics. We'll bring them around to the audience members, and then I'll make sure we end it right about 6.
Okay.
And they're going to be setting up the wine and beer and the reception and everything. So there'll be plenty of time to people talk to you afterwards. So I think that's it.
Do you have a link to the live stream?
Yeah. Well, it's on the Hartwick Institute of Public Service.
Yeah.
It's posted. Like if you go to
message it to me?
yes. So here you are, and here's your live stream link. Is it not? It's working for me, I think.
Okay, yeah.
Oh, look at it. Here we
there.
are. Yeah, so, right? Does that not look right?
Yep.
So, should I give him that link or just the link to the Hartwick Institute of Public Service
That
page?
link directly.
Oh, but how do I do, okay.
If you go back to share.
Share. Do you want me to email it to you or
No,
text?
just text.
Okay.
832.
Okay, I'll probably make a mistake.
Me.
Okay.
You lost
And it's going to be as soon as it's done, right, Chris? It'll convert to like, or soon after?
Yeah,
Convert to a-
yeah, you'll be able to watch it from that link. Just know that the first 15 minutes you'll have to skip
Okay.
through until the start.
Okay.
Yeah, so it will be up there. We'll have it up there for a long time. So.
So don't mess up.
Well, you know.
Do you know?
It's not like we get
Do you know that?
millions of people to our YouTube, but
You know
close.
that there's a crime in the military called contempt towards officials.
just get these going, and then, right? So,
Yeah. This is so chill.
okay, I think we're good.
We're good? Hi, welcome. Thank you all for coming to our 2025 Constitution Day talk. My name is Madeline Rodiger, and I'm a sophomore here at Hartwick. I'm particularly honored to help introduce tonight's Constitution Day speaker, not only because of my own interest in the law, but because events like this represent what's so special about Hartwick, the opportunity to engage deeply with important ideas that shape our democracy. As a first-year student, I was one of 60 Hartwick students who participated in our moot court competition, which I was fortunate enough to make it to the finals. That experience confirmed my passion for the law, which I continued to explore this past summer through an internship with my county district attorney's office. This semester, I'm completing a public service internship with the Hartwick Institute of Public Service, the nonpartisan organization sponsoring tonight's talk, along with Hartwick's law program and Office of Civic Engagement. The mission of Hartwick's Institute of Public Service is to engage young people in democracy and inspire and prepare a generation of new leaders. Our Constitution Day speaker embodies this mission perfectly. And to tell you more about him, I'm pleased to turn things over to Brennan.
Thank you, Madeline. Good evening, everyone. My name is Brennan McNeely, and I'm a senior double majoring in economics and political science, and a proud member of the Hartwick football team. Like Madeline, I am honored to help welcome tonight's Constitution Day speaker. It is a particular pleasure to introduce Professor Jeffrey S. Korn, not only because of his extraordinary career, but also because he is one of our own. He earned his bachelor's right here at Hartwick College. Professor Korn is the George R. Killiam Chair of Criminal and Law and Director of the Center for Military and Policy at Texas Tech University School of Law. Before entering academia, he served for 21 years in the U.S. Army, retiring as a lieutenant colonel and then spent an additional year as a civilian legal advisor. During his Army career, he held numerous key positions, including Chief Prosecutor for the 101st Airborne Division and the Army's Senior Law of War Expert Advisor. Professor Korn is a leading scholar on the law of armed conflict, national security law, criminal law and procedure, and prosecutorial ethics. He has testified as an expert witness before the Military Commission at Guantanamo Bay, the International Criminal Tribunal for the former Yugoslavia, and in federal court. He is also the author or co-author of numerous books, including National Security Law and the Constitution and the Law of Armed Conflict in Operational Perspective. Tonight, he will deliver a very timely and important talk titled Commander-in-Chief or Constitutional Overreach. Please join me in giving me a warm welcome to Professor Jeffrey Korn.
Well, thank you for that welcome, and it's a delight to be back here. I would be remiss to not thank your Professor Elder for building this connection with me after 35 years of absence from Hartwick, not because I had any bad feelings about my experience here, but simply the lifestyle that I chose, living all around the world, that made it hard. I would get the Wick magazine and look at the alumni news and see events and be a little envious that I was not stationed somewhere like, I'm not going to say I wanted to be stationed at Fort Drum, but be envious that I wasn't stationed somewhere closer. But when I finished and I started teaching in Houston before I moved to Texas Tech, we built this connection, and I am honored to be here. I'm also honored to be introduced by two fine students, especially one who shares my roots on Eastern Long Island. So thank you very much. When Professor Elder asked me if I wanted to be the Constitution Day speaker, I jumped at the opportunity, the chance to be back here. The first time I've ever brought my wife to see Hartwick, my wife who I met when I was sent as a second lieutenant to Panama in 1984. The best thing the Army ever did for me. I'll say it over and over again. And it's just so beautiful. What a beautiful day. How lucky you are to be students here, faculty, members of the community. And this program that has been created, this institute that's been created, is really remarkable. And actually, I think one of the themes from today's talk that I hope you take away from the presentation is that in the end, what this case I'm going to tell you about really teaches us is that if we want to protect liberty by preserving limits on the authority and power of the chief executive of the nation, we can't expect anybody else to do it but us. In the end, it's just us chickens, because the ultimate check on executive power, particularly in the realm of national security, and especially when there's assertion of authority derived from the Commander-in-Chief Clause of Article 2 of the Constitution, is not going to be the courts, it's not going to be the media, it's going to be the legislature. That's the structure that was created in our organic document, our Constitution. And that's really what I want to talk about today. Now, I want to emphasize at the beginning that as a law professor, particularly teaching a class called National Security Law, which I'm teaching now, it's very important for me to emphasize that I hope to be apolitical. I don't really care who's in the office of president. I don't really care what party that person is from. This is not a political discussion. This is a discussion of law, law that binds or should bind all presidents, and law that should animate the decisions of all Congresses in order to preserve the liberty that is at the core of this government that was created by our founders in 1787. And as a matter of fact, one of the things I'm going to highlight for you is how current events we're watching, particularly with these attacks on boats in Venezuela, are an extension of theories that were developed by a prior president and implemented by other presidents. That prior president was President Obama. So there's a snowball effect to assertions of presidential authority, particularly in the realm of war power, that we have to acknowledge, and we have to recognize where some of these theories are coming from. It doesn't mean we have to accept them. It doesn't mean we have to agree with them, but we have to understand their origins if we are going to critique them legitimately. We're taught as an article of faith, starting, I think, in grade school, that the founders, when they gave us the Constitution, separated powers. But actually, I think that's a bit of a myth. And the Supreme Court has reminded us that that's a bit of a myth for a long time. What the founders really did was separate authority over certain government power. So think, for example, of the government power to wage war. That power is not separated. That power is shared between the legislature and the executive. The Congress has immense power over war. The power to declare war, the power to grant letters of marque and reprisal, to raise and support armies, to provide for a navy, to make rules for captures on land and water, to define and punish offenses in violation of the law of nations. And let's not forget the residual power to make all laws that shall be necessary and proper to carry into execution the authorities granted to this government. And yet we also know that the president, as chief executive and commander-in-chief, has immense power over war. In fact, if we think about separation of powers, there are very few powers related to national security that are purely separate. Almost all of them are interspersed. And that was deliberate. That was calculated. Not to make our government more efficient, not to make our government more effective, but to preserve liberty and prevent the aggrandizement of power. Here's what Justice Louis Brandeis said in his dissenting opinion in 1926. Is that big enough to read? Okay. I'm not a PowerPoint person normally. I don't tend to use it in class. I don't begrudge those who do, but when I use it, I'm always in fear that I'm not using it properly. But look at what he says. The purpose was not to avoid friction, but by means of the inevitable friction incident to the distribution of governmental powers among three departments, to save the people from autocracy. You take a power of the government and then you disperse authority to exercise that power, and the concept behind it is to generate friction. That friction creates compromise, that compromise creates unity, that unity makes us stronger as a nation. The theory behind this division of power. Now, there's also an understandable reality that in the realm of government action, perceived necessity will also often lead chief executives to act even when they're not sure they have the authority to do so. Or maybe more accurately, to see a need to act and then craft a theory of authority to justify that action. Because the force and effect of chief executive is that you are responsible to answer to the people to resolve problems. How do we sort this out? How do we decide when the president can assert such power and what the limits are on that power? And if you study national security law or you practice national security law, you always come back to one seminal Supreme Court opinion. That is a little bit surprising. In 1952, the United States was involved in a conflict in Korea, a very serious war that took the lives of about 38,000 American service members and many, many more Koreans and Chinese and United Nations forces. In the midst of that war, there was a labor dispute between the steel industry and labor, and there was a strike. And President Truman was concerned that because of the strike, it would interrupt the production of armaments for the armed forces. So he saw an emergency. But he had a problem. There was a law that's still in effect called the Taft-Hartley Act, that gave the president the authority to mandate arbitration between the parties. But he couldn't force a resolution. And when Congress had considered that law, when it had drafted that law, it had actually considered giving the president emergency seizure authority. They thought about it, and they rejected the idea. So the statute did not authorize the president to take over the industry to end this labor dispute. But he thought there was an emergency. Now, Truman was a consummate legislator, as historians know. He believed in the legislative process, but he also knew that he was in a position where he had to act. So he acted. He issued an executive order. Here's what he cites as his authority. By the authority vested in me, by the Constitution of the United States, statutes of the United States, as chief executive and as commander-in-chief. Let me throw everything I can into the blender, turn it on, and he orders the Secretary of Labor, of Commerce, to take over the industry. And if you own that industry, what are you going to do? You're going to sue the government. You're going to seek an injunction. You're going to allege that you have been deprived property without due process of law. Because if the president takes your property without statutory or constitutional authority, then you've been deprived due process. That's the essence of an arbitrary taking. So they sue the president. The first district court judge gets the case and says, I'm not sure a court has authority to issue an injunction running to the president. Then they go to another judge, and the judge says, I don't have to issue the injunction against the president. I can issue it against the Secretary of Commerce. And he does. And it goes up to the Supreme Court. The government appeals it. And it becomes the case of Youngstown Sheet and Tube versus Sawyer. We know what the president's dilemma was. We know what his executive order did. We know what his asserted authority was. So now you're the Supreme Court. You're the 12 justices of the Supreme Court, and you've got to decide something. The president says there's a national emergency. Troops are in the field. They need bullets and ammunition and equipment. Congress has not given him the authority to seize a steel mill. He says, I don't need their authority because I am acting in response to an emergency. And as chief executive, you should acknowledge that authority for me. Sound familiar? Sound familiar? A little bit, right? This is why this case becomes so important. So important as a almost supplement to the Constitution when we're dealing with national security, that the former dean of the Harvard Law School, who then became the legal advisor to the Secretary of State, to Secretary Clinton, Harold Hongju Ko, wrote a book years ago titled The National Security Constitution. And his thesis was the effect of this case, the methodology, that the court articulated in this case gives us a almost supplement to the text of the Constitution to work through questions of executive power when the issue involved is national security. I did a search. I have a book remind me your first name. Brendan said, I co-authored a textbook called The Constitution and National Security, and I did a word search for Youngstown Sheet and Tube versus Sawyer, and over 65 times it's cited. The case that just came out of the Ninth Circuit, where the district court judge issued the injunction against President Trump for using the California National Guard, Newsom v. Trump. He applies this case. This is the case for figuring out how to sort through these problems. And the reality is that because of doctrines of what lawyers call non-justiciability, that means reasons a court will not take a case. You don't have standing in the matter. You're not affected by it, so we're not taking the case. Or it's a question that should be resolved by the political branches, what we call a political question. We're not taking the case. Because of that, there are not precedents in the realm of national security law like there are when I teach criminal law. When I teach criminal law, I have to teach students what's the meaning of malice. I can find 100 cases where courts have said, this is what malice means and this is how you prove it. I can't do that in national security. So the case takes on elevated significance because if I'm a legal advisor or a critic of government action, I'm looking through this lens. And that's why I want to emphasize this case for you. Well, let me back up. I want to tell you a little bit about the way the case plays out. It's a 6-3 opinion, and the court strikes down the president's executive order. Court rules in favor of the industry. Justice Hugo Black, anybody ever hear of Hugo Black? Interesting guy. He was in the KKK when he was a young man, but he was reformed. As a matter of fact, when Thurgood Marshall was appointed the first African-American justice on the Supreme Court, he asked Hugo Black to swear him in. He was a real populist, but he was also a textualist. The first TV interview in the Supreme Court building was by CBS, and they interviewed Hugo Black, and I love watching it because he sits there and he says, he takes out a little pocket constitution. He says, see this document? I think every case that comes before this court can be resolved just by opening this document and reading the words. He was a textualist. He didn't think there was anything other than the text. He looks at the case and it's simple for him. He says, Congress didn't give you the authority to do it because they considered giving it to you and they didn't do it. There's nothing about being commander-in-chief that lets you seize industry. You can't say you're implementing the take care clause of the second article of the Constitution because that's take care that the law be faithfully executed. There's no law to execute. Simple. And oh, by the way, only Congress can provide compensation for a taking. So ipso facto, only Congress can authorize a taking. His opinion's not the one that's most significant. The most significant is by an associate justice named Robert Jackson. Robert Jackson, in my view, reading his many opinions, was the ultimate pragmatist. He understood some things. His background is interesting. He was born in Pennsylvania, grew up in Jamestown, New York, never went to college, apprenticed for a lawyer, spent 1 year at Albany Law School and then sat for the bar and was admitted and had a remarkably successful career in Western New York and then went to Washington. He was Solicitor General of the United States. He was appointed by Franklin Roosevelt as his Attorney General at a time when Roosevelt was trying to figure out how to help the British when they were dealing with the Germans, when Congress was resisting all of the efforts of Roosevelt to support the British. Who's the guy giving him legal advice on how to work through this emergency? It's Robert Jackson. So he understood that part of the equation. He understood how presidents look at the world and look at problems and view the necessity of action. He's appointed to the Supreme Court, and at the end of World War II, Roosevelt puts him on a leave of absence so he can go serve as the chief prosecutor of the Nuremberg tribunals. So he learned something else. He learned the consequence of autocracy. He learned the consequence of abuse of power, of aggrandizement of power. He understood all of this. And it's palpable in his concurring opinion. And that's the opinion that has the most significance from this case. It's not Black's majority opinion. It's Jackson's approach to figuring out how to work through this problem. Here's what he says. While the Constitution diffuses power to better secure liberty, it also contemplates that practice will integrate those dispersed powers into a workable government. It enjoins upon its branches separateness but interdependence, autonomy but reciprocity. And his whole theory is that when you're assessing executive power, you have to focus on the degree of conjunction or disjunction to legislative power. And he lays out what he calls a conceitedly oversimplified framework for assessing power. He says, we may begin with a somewhat oversimplified grouping of practical situations in which a president may doubt or others may challenge his powers, and by distinguishing roughly the legal consequences of this factor of relativity. So notice that Black takes a very simple approach. I don't care that the president says it's an emergency. I don't care that he thinks he has to act rapidly. What I care about is black and white. There's no authority to do this, you can't do it. Jackson is more subtle. He uses the opinion as an opportunity. I think to issue what the Supreme Court says it's not supposed to issue, which is an advisory opinion. He's giving advice on how executive advisors, legal advisors, courts, critics should assess executive power. These are the famous Jackson 3 tiers. Where does the president's action fall? When the president acts with the express or implied support of Congress, his power is at the maximum, for he's acting not only with the power of his office, but with the whole nation, the zenith of presidential power. And if the president is acting up there, the president wins with one exception, and that is the combined exercise of power violates the organic law itself. So let's hypothesize that Congress enacts a law tonight that gives the president the authority to allow ICE agents to enter homes anytime they want based on any feeling that there might be something in there they need to know. He's acting at the zenith of his power. A court will strike it down because Congress and the president cannot violate the Fourth Amendment by statute. Let's go to the bottom. Ooh, that should be 1, 2, 3. See, my PowerPoint expertise. Let's go to the bottom. When the president acts contrary to the express or implied will of Congress, his power is at the lowest ebb. Because if we allow the president to act in that realm, he is potentially invading on the prerogative of the legislature. When should he win in that realm? In the very rare instances when the Constitution vests him with power that is so plenary, so absolute, that Congress is not allowed to intrude upon it. So if Congress were to enact a law that said, you may not appoint a graduate of Hartwick College to be an ambassador, the president could do it anyway. Because there his power is absolute. Now he has to get consent from the Senate, as we know, but they can't intrude on that exclusive power. Look at the middle tier. When the president acts in the face of congressional indifference, quiescence, or inaction. Then Jackson says he's kind of acting in a twilight zone. Let me read to you what he wrote. When the president acts in the absence of either a congressional grant or denial of authority, he can only rely on his own independent powers, but there is a zone of twilight in which he and Congress may have concurrent authority, or in which its distribution is uncertain. Therefore, congressional inertia, indifference, or quiescence may sometimes, at least as a practical matter, enable, if not invite, measures on independent presidential responsibility. In this area, any actual test of power is likely to depend on the imperatives of events and contemporary imponderables rather than abstract theories of law. You see, what Jackson understood is that presidents find themselves in a position where action they deem is essential. And they don't know what Congress wants. Imagine. Imagine a crisis where Congress is playing the fence. Imagine sometimes Congress doesn't act decisively. Now, in this case, Jackson says, you're down at the bottom. Because when they denied you the authority to seize industry, that was as if they put it in the statute. So now the only question is, do you have any independent constitutional authority that overrides that statutory restriction? And Jackson goes seriatim through the Solicitor General's arguments. Commander-in-Chief clause, Jackson says, I will indulge the broadest authority to the Commander-in-Chief when he's acting externally against an enemy. But when the founders made the President Commander-in-Chief of the Armed Forces, they did not make him Commander-in-Chief of the nation. And when he turns that power inward, not in response to a rebellion, but in response to an economic dispute, he has no authority to do so. The vestiture clause, very interesting, because there are two vestiture clauses in the Constitution. Article 1 vests Congress with its authority. It says, all legislative powers herein granted shall be vested in a Congress of the United States. But Article 2 says, the executive power shall be vested in a president. There's no herein granted qualifier. And presidents always cite that. They rely on a case from 1936 called Curtis Wright Export Corporation, where Justice Sutherland said, that tells you that that vestiture clause includes inherent executive power. The power that's inherent in being chief executive, even though it's not listed. It's different than Article 1. Jackson says, that doesn't make any sense, because if that's what they meant, why would they put any powers in there? Why would they say he's commander-in-chief? Why would they give him the power of appointment? Why would they give him the power of making treaties? Those are executive powers. So he rejects that argument, and he also rejects it because he says, if there is a residual emergency power vested in the government, it's in the legislature, in that necessary and proper clause, not in Article 2 for the chief executive. Take care clause, same as Black. You can't take care of law. You can't take care to faithfully execute law that's not law. So Jackson just goes through, and he says each one of those is insufficient to overcome the fact that Congress has said you couldn't do it. But just imagine that the legislative record of the Taft-Hartley Act had not included that discussion, where Congress considered giving him the power and chose not to. He would have been in that twilight zone. And I think there's a very high probability Jackson would have said, okay, Congress knows what you're doing. You gave them notice, and they're doing what? Nothing. We don't know what that means, but we do know there's an emergency. And even his fellow justice, Felix Frankfurter, said, you know, I might have been willing to tolerate this if the president had put an expiration date on it, if Congress didn't act in that period of time. Like, I'm seizing it for a week to put pressure on you to authorize it statutorily. These justices are recognizing the dilemma that presidents find themselves in. But they're also recognizing that emergency does not create power in government, and power in government does not ipso facto vest it in the president. And that's the task of figuring out what he can do and when he can do it. So like 5 other justices, Jackson concludes the president was acting at his lowest ebb. He then rejects the claim of independent constitutional authority derived from those provisions of Article 2 of the Constitution, the president's article. But Jackson's opinion, when I went to law school and I read this opinion for the first time, it was taught to me as an opinion directed at the president. And over the years as I've taught it, I don't think so. I think Jackson was directing it at Congress. I think he was warning Congress. You know what? You got lucky this time because you happened to have a legislative record that had the right language in there. Had you not had it, things may have been very different. Remember, 3 justices voted to support the president. He only needed 2 more. Jackson says emergency doesn't create government power. Government power doesn't vest it in the president. Just because there's power to respond to emergency doesn't mean it's for the president to use. The founders contemplated the need for extraordinary emergency action, and they vested it in the Congress in the necessary and proper clause. But, ... Read that. Amazing. Amazing. Ooh, I get chills. I literally just got chills reading it. By the way, I was talking with one of the professors today who's a historian, and one of the joys of law for me is that law and history are indelible. You cannot understand this case if you don't know the history of the Korean War, if you don't know the history of Robert Jackson's life experience. You can't. But he's telling Congress, it's your job to check aggrandizement of power, because the reality is, as Napoleon said, the tools belong to the man who can use them. And if you give him the tools or you let him use the tools with indifference, guess what? It's going to generate more effort to do more. Now, let's apply this to two specific war powers moments we've dealt with in the last couple of months. The first is Operation Midnight Hammer, the U.S. attack on Iran. The president was very overt that he was planning this attack. It was no secret. Congress was aware of what was being planned. There is solid constitutional jurisprudence that indicates the president is vested with an inherent authority to use military force to defend the nation against an actual or imminent armed attack. That's why the president carries the nuclear football. He doesn't have to go to Congress if the Russians are about to launch a nuclear missile at us and say, may I please have permission to intercept it? This comes from the Civil War, from a consolidated group of cases called the prize cases. Again, history, where the court said President Lincoln acted constitutionally when he responded to the rebellion by meeting force with force because it was thrust upon the nation. This is why President Bush and Vice President Cheney scrambled fighter pilots above New York and Washington, D.C. on 9/11. We had been attacked. We were the victims of an armed attack. So you've got a source of inherent presidential authority, maybe being stretched a little. Is there really an imminent threat from Iran? But the president is entitled to some deference of judgment. But more importantly, what does Congress do on the lead up? Nothing. Nothing. So if you're the president's legal advisor, at best, you're in tier one because you're acting with the implied support of Congress. At worst, you're in tier two. And you've got this inherent power that's been recognized by the courts and other presidents, by the way. Every other president has recognized this power. I think solid ground. I might not like the fact that we did it. I might wish that there had been a different option. Congress certainly could have stopped it. As soon as he started talking about it, they could have enacted a law over his veto that said no military force will be used against Iran. But they didn't. And I think we know why. If it went really well, they can say what? We were with you all the way. If it went badly, they can say we never authorized it. This is the reality that Jackson dealt with, and he knew Truman was dealing with. Now let's contrast that with what's happened in the Caribbean recently. The president's language. He gave a war powers resolution notification to Congress the other day. He's using the language of the nation being under attack, that these drug gangs are no different than Al-Qaeda because of the deaths caused by fentanyl every year. Now, I don't want to minimize for a second the suffering caused by illegal narcotics. But in my view, there's a fundamental difference between treating Al-Qaeda as a threat of an attack against the nation when their goal is to kill us, and treating drug gangs in the same category. And I'm not even talking about international law. At the international law level, it's equally troubling because the nation is only permitted to exercise self-defense in response to an armed attack. I don't think this is a justified use of military force. But what I don't think doesn't really matter because there's no justiciable issue here. No court is going to adjudicate this. The president is invoking, by the way, the Obama doctrine. Remember I said that there's good precedent for the president responding to an attack on the United States. Even the War Powers Resolution, which was Congress's effort to rein in presidents, says the same thing. It says the president may act in response to an emergency created by an attack on the United States, its territories, or its armed forces abroad. What President Obama did for Libya, and then when he was planning to conduct an attack in Syria over chemical weapons, is he said, my inherent authority extends to protecting vital national interest. Vital national interest. You see how that's different than protecting from an attack on the United States? And then President Obama said, preserving the NATO alliance is a vital national interest. Therefore, I have inherent authority to send our forces to war. So what do you think the War Powers Resolution characterizes the flow of narcotics in the Caribbean as threatening? Our vital national interest. What would Jackson say? Hey, members of Congress, if you think the president is aggrandizing too much war power, the burden is on you. And I understand politics. Jackson understood politics. There's a whole paragraph in his opinion where he says, the president doesn't need the court to make him any stronger. His power has grown over the decades, and in a system of party loyalty, it's even more powerful. And he's got the bully pulpit. He doesn't need us. We need Congress. This is sad for me. This is sad. I was having a discussion earlier with one of your colleagues about another conflict, and I think he would tell you that I am very supportive of the authority of the military to do its brutal mission. Close with and destroy the enemy by fire and maneuver. But if you're not in a war, you cannot kill somebody as a measure of first resort. That's an unjustified killing. And that's what the orders are being transmitted to do in a period of uncertainty. And if I were at the receiving end of those orders, I'm not sure what I would do. I would say, is this stretching the envelope or is this tearing it apart? And you expect a JAG colonel or major at the tip of the spear to advise his commander, you should disobey that order? This is not fair. This has to come from our legislators. If they want us to be in a war against Tren del Agua, authorize it and put limits on it. That's what Jackson would say. Because if you don't, guess what? The man with the tools will use them. So hopefully that was insightful or interesting, and I've left 20 minutes for provocative questions. So let's have them.
Colonel, so isn't this normally a force that the Coast Guard uses?
Yes.
To board and search and seize?
Yes, historically, this is a law enforcement operation. If you want to read something very interesting on it, you can Google a guy named Mark Nevitt. Mark is a retired Navy JAG officer who is now a law professor at Emory Law School, and he wrote exactly about this. He was involved in those operations. The Navy provides backup. If you look in the Naval Commander's Handbook on Law, there's a whole chapter on counter-drug operations. And you know what it says? You can use force in self-defense just like a police officer can use force. Here's the analogy I've used, because I've had arguments already with people. Well, look, 80,000 Americans die every year from narcotics. By the way, I looked up, the CDC said last year 178,000 died from alcohol. We haven't designated Jack Daniels as an enemy armed group, right? Not to be dismissive, but my analogy is if I'm a police officer in Oneonta and a block away I see a known fentanyl dealer transferring fentanyl to a buyer, do I have authority to shoot him on the spot? Of course not. Yes, the drug is deadly. Yes, it may result in serious harm. I can only resort to deadly force as a measure of last resort. But by rhetoric, what's the first thing you do? Invoke the National Emergencies Act, a law Congress gave the president. And Congress can suspend it, but they have to act. Second thing you do, designate them a foreign terrorist organization, which, if you know the law, has zero impact on whether you're in a war. All it does is open up prosecution under the Material Support for Terrorism statute. Third, talk about the degree of harm being inflicted, analogize it to Al-Qaeda and ISIS, and now you invoke what? War power. And I don't think the president, honestly, I'm quoted in the Wall Street Journal, the New York Times, I don't think the president has constitutional authority to order these missions.
Well, nobody forces fentanyl down your throat either.
It's the human agency part is another factor. But again, I want to be very clear. I am not in any way minimizing the harm caused by fentanyl. Matter of fact, I applaud the president for the FTO designation. I'm glad he did it. I think if you're in the United States and you're doing anything to help these groups get these drugs in the United States, you should be prosecuted for material support to terrorism. Go get them. But I did an interview with Turkish television about when he was talking about going into Mexico. And they said, we did a report from Mexico, or from El Paso, where the chief of police was showing us the smuggling tunnels. I said, El Paso is the safest city in the United States. If these drug groups were here to hurt us, what you'd be seeing is completely different. They are not like Pancho Villa when he rode across the border in Columbus, New Mexico, and launched an armed attack against the United States. All right.
Thanks so much. Thanks so much, Professor Korn. I'm curious your thoughts on the case of Trump v. the United States. Obviously, that's dealing with presidential immunity and not necessarily within the context of national security. But just given the fact that it seems like the Supreme Court basically has authorized the president that they can do anything as long as they're acting in an official capacity, you know, in dissent.
Or maybe even a quasi-official.
Right. Said that basically this gives, you know, the president the power to order the killing of a political enemy. And I'm just curious what impact you think that case has on issues of national security and presidential power.
I mean, to be fair, I think there's an element of speculation there. I mean, my guess is what happened was the president and his people said, we've got to be more aggressive against these gangs. I want to show more strength. And so you get lawyers who come up with a theory, right? And if you surround yourself with lawyers whose goal is to get you to yes, as opposed to speak truth to power, you're going to get the theory you want. I don't know President Trump. I know people who've met him. My brother used to be a high-level intelligence official and has met him many times and said behind closed doors he's thoughtful and he listens. I mean, my guess is if we could bring him in and say, why do you think you have the authority to do this? He'd probably say, because my people told me I did. So I am skeptical that there are meetings where, well, I can get away with ordering murder, so let's just do it. No, but you bring something else up. That immunity does not extend down the chain of command. There's a federal criminal statute that makes it murder to unlawfully kill another human being in international waters, because that's special territorial and maritime jurisdiction of the United States. The Uniform Code of Military Justice, crime of murder, Article 118, applies everywhere all the time. But one of the things that the administration did was they issued an executive order about the primacy of executive branch opinions. And one paragraph of that order talks about legal interpretation. And it says, the legal interpretation by the top lawyer of the executive branch is binding on the executive branch. Now, I don't think they can nullify the ethical duty of a lawyer to provide independent judgment, okay? And having been a lawyer who's had to tell a senior commander, you may not do that, that is not a good day when you're a captain. Trust me, okay? They are not used to subordinates saying, you may not. That's not an easy thing to do. But there's an interesting criminal law doctrine that's been implicated now. And I don't want to get too deep in it because not everybody's interested in criminal law. You see, I'm a chair of criminal law. I love teaching it. There's a doctrine called mistake of law. Now, mistake of law is normally not a defense. You cannot rob a bank and then say, I had no idea robbing a bank was illegal, because most law doesn't require you to know that it's illegal. But there's a very narrow exception for what they call detrimental reliance. When someone detrimentally relies on a legal statement that is given by an authority over that law, later proven to be erroneous, they have a defense. That executive order, I think, has created a mistake of law for any potential liability that might come in the future. Because if I were representing somebody in that chain, in the future, I would say there's an opinion by the Attorney General that this is a lawful exercise of military authority. The obligation under the executive order is to follow that because that's stated as the senior lawyer for the executive branch. Okay, maybe she was wrong, and we say that now, but the guy who followed it, you can't punish him because he relied to his detriment on that erroneous opinion. It's very complicated. That would be a defense in a court-martial as well. And you better believe if I were representing somebody, I'd be pushing that as hard as I could. By the way, I think it was a terrible opinion. I don't think it was just because of the consequences of it. I just think it was poorly reasoned. The dissent, had a much more reasoned explanation of why the Constitution does not immunize the president from congressional criminal statutes.
Okay. So my question, it might be more of a simpler answer that you'll give, but it's more on the lines of the use of the National Guard that has occurred within D.C., L.A., Chicago, and there's first the aspect of, yes, the president can only have them for 30 days unless Congress says he can extend it. But what other limitations could occur, like if there's a situation involving, again, the rise in protests within these cities from different folks protesting against the National Guard being used?
I have it in the notes here. Your professor gave me a strict timeline, which I violated. But I didn't want to violate anymore. I didn't want an egregious violation. Okay? It's a great question. Have you read Newsom v. Trump, the Ninth Circuit opinion?
I know a summary version of it, but if you can give a more...
You ought to read it.
Yeah.
Because it's a tour de force, and it's all based on Youngstown. Ultimately, what the district court judge concluded was that when Congress enacted Title 32 of the U.S. Code, which is the provision of the U.S. Code that allows National Guard soldiers to be brought onto full-time duty, not under federal authority. The president doesn't want them under federal authority because then he implicates a law called the Posse Comitatus Act, which limits their ability to enforce law. He wants them on full-time duty under state authority, but he wants to direct it. Here's what the statute says. Title 32 provides the President or Secretary of Defense with authority to order the National Guard into training status. The training or duty ordered to be performed under paragraph 1 may include the following. You ready? Support of operations or missions undertaken by the members of the unit at the request of the President or the Secretary of Defense. That came after Katrina. Before Katrina, all it said was you can bring them onto full-time status to train them. But Congress added a provision. So what tier do you think the president says he's acting in? Number one. What the judge did is he said, I looked at the legislative history of that provision in the broader context of the Posse Comitatus Act, and I don't think that's what Congress meant. So now it's teed up. The Ninth Circuit has suspended the opinion. It's going to go to the Supreme Court, and I think the Supreme Court's going to rule for the president. Because they are going to say, if that's not what Congress meant, all Congress has to do is what? Change the law. They're stuck with it.
And I guess maybe like a smaller side question would be, has there been a different U.S. president that has done something similar in this reign that did cause some challenge?
Not the tinkering with the National Guard. Let me explain that to you, so just briefly. Our military is in two different categories: federal military forces and the National Guard. Congress, in Article 1 of the Constitution, is vested with the authority to provide for calling forth the militia. They've done that in statutes. They give the president the authority to take the militia, the state National Guard, and pull it into federal service. When he pulls them into federal service, they're subject to the same law that I was subject to as an active duty soldier, the Posse Comitatus Act. And the Posse Comitatus Act says, to summarize, federal military forces may not be used to enforce law unless authorized by statute or the Constitution. Now, have presidents done that to enforce law? Yes. When the National Guard in Alabama was obstructing integration, President Kennedy pulled them into federal service. If you watch Forrest Gump, when they hand the guy on the steps that note, that's a real moment where Deputy Attorney General Kastenberg handed the note to the commanding general of the Alabama National Guard. You know what it said? President Kennedy has just put you under federal authority. Stand down. That's his order. President H.W. Bush invoked the Insurrection Act for the LA riots. So the president has the authority to invoke the law. By the way, there's no definition of insurrection. So he could call something an insurrection. They've been creative about avoiding that. But no president has done that. No president has said, I want to use the National Guard at my direction, not the governor. If the governor needs to call out the National Guard, fine. But I want to call them out, use them to help enforce law without putting them under federal authority or invoking the Insurrection Act. It's very creative. The problem is, if you read the statutes, it's got the maneuver space. It's going to be a very interesting case on appeal. But if you're interested, it actually is a really remarkably well-written case on the history, again, history, on the historical aversion of the American people to the interference of the military in domestic affairs. That's the framework the judge starts with.
Thank you.
Thank you.
My question is about refereeing the Korean War, 1952. I was around at that time. I remember hearing that maybe it was a police action or it was a war. I know the history books now refer to it as the Korean War, but there was some question at the time about police action. My thought is, would it have mattered anyway?
No. As a matter of fact, in Youngstown and as far back as the quasi-war with France, right? The quasi-war with France, when the U.S. Navy was fighting the French on the high seas before the War of 1812, the Supreme Court has said war can be de jure or de facto, perfect or imperfect. What's a perfect war? A legally perfected war. How do you legally perfect a war? You declare it. There have been 14 declarations of war in U.S. history by joint resolution. 14. You know what the last one that you win a beer or a drink? This is a trivia question. Who is the last country we declared war on? Germany. What? Germany. Nope. Romania. The last list on the last letter on the Axis list, but I mean, it's true. Last one, 1942. But, but that language of police action was rhetorical. It had no constitutional legal significance. Actually, the Korean War was up in Tier 1 because when Truman drafted an authorization for the use of military force, he went to the Senate Majority Leader, again, history, and said, I want an authorization. The Senate Majority Leader told him, you don't need it, and we're not putting it up for a vote. You've got the money. We're extending the draft. We're calling up reserves. You've got our implied support. And by the way, in 1973, when Congress enacted the War Powers Resolution, what it tried to do was eliminate that middle zone. Because it said, if you don't have express authority, you have no authority. Which is why every president has said, that's unconstitutional, because for 240 years, we have been relying on implied authority. And you can't change that with a statute. And they still do. What authority did President Trump have to launch the attack against Iran? If I were his advisor, I would have said, you've got the implied consent of Congress. And that's what Truman had for the whole war. Now, that's important because if Congress wants to resist the war, it can withdraw consent. But it's got to do it. And what the War Powers Resolution did is it tried to give him an easy way out. If you do nothing, it puts him in the bottom tier. No. What did Jackson say? If you do nothing, he's at worst in the middle tier. If you want to stop the president, enact a law.
Mark? I'm very interested in your insight into the tariff issue. It seems to me that that's a really good example of inaction on the part of Congress. And it makes me wonder if the Supreme Court is going to kick the can down the road.
No, actually, I think it's a good example of Tier 3. Because the president has ordered these tariffs by invoking a law called IEPA, the International Emergency Economic Powers Act, which is a successor law to a law before that called the TWA, the Trading with Enemies Act. IEPA gives the president a lot of economic tools to deal with a national emergency. So he declares a national emergency, then he invokes IEPA. IEPA is silent on tariffs, doesn't say anything. The reason that the president has lost so badly at the intermediate courts is they've said, what? It doesn't give you the authority to impose tariffs, which means you're in what tier? Tier 3. And in Tier 3, you would have to point to a provision of Article 2 that gives you plenary authority to impose tariffs, and that authority is vested in the legislature. You want to do tariffs? Fine. Go to the legislature and get them to add it to IEPA. Now, no one can predict what SCOTUS does, but I think he's going to lose that one at that level. Now, I don't think he's going to lose forever, because if I were the president's advisor, as soon as I lose it, I go to who? Go to a Republican Congress and say, amend IEPA. And we'll see what happens. But at least then there's a deliberative process, which we haven't had on that.